Good evening and hello. My name is Shiloh Dahl. I'm an eminent domain lawyer with the law firm of Seaver Story Walker. We're based in the Midwest. I'm coming to you today from the Southeast in North Carolina, where I'm an attorney and have been for approximately 20 years now. I want to talk with you tonight and have invited participants to learn a little bit more about the eminent domain process, generally speaking, and specifically how it applies in Utah to the Limber to Terminal power line project. While I don't have detailed remarks to lead into, I did want to at least say hello and introduce myself to you before I transition into my presentation prepared remarks. I expect I'll go about 30 to 40 minutes or so. There'll be plenty of opportunity to ask questions along the way if you want to just put something in the chat. Otherwise, if you have additional questions, I encourage you to spend some time visiting our law firm website. That's www.landownerattorneys.com. That information is also on the invitation letter, as well as my email and direct telephone contact. That will also be scattered throughout the presentation. So without further ado, I'm going to go ahead and transition to sharing my screen and begin the presentation so we can move forward quickly. As I said, tonight's conversation is focused on the Limber to Terminal segment of the Pacific Energy Corp's Gateway Expansion Project. Some of you may know Pacific based on its trade name, Rocky Mountain Power. I'm going to use those two terms interchangeably. But what you're ultimately here to understand is get a better sense of what your rights are as a landowner, as somebody who's going to be affected by this power line project. I want to tell you a little bit about what you can expect. I'll begin with some basic disclaimers and some information limiting sort of the details of what we're going to talk about tonight. I'll briefly introduce myself and our law firm more than I just have. I'll give you some basic information about this project, as well as any updates that you might be able to expect in months ahead. The bulk of the conversation will be about essentials for you to understand as a landowner who is encountering this process in all likelihood for the very first time. We want you to understand the eminent domain and the condemnation process in Utah well in advance so that you can begin to prepare yourself, your family, and put yourself in the best position to protect yourselves, your legal rights. As I said, just a couple of quick disclaimers and disclosures. We are not working or in any way affiliated with Rocky Mountain Power or PacifiCorp. They are the company behind this project. So we would be, generally speaking, on the opposite side. We don't represent any of those utility companies. And in fact, we never represent utility companies or condemning authorities like departments of transportation. Our law firm is dedicated solely to protecting landowners on this side of the equation. Importantly, though, nothing I say tonight is all considered general information and shouldn't be considered personalized, definitive legal advice applicable to your circumstance. No attorney-client relationship is created or should be expected in connection with today's commentary and this seminar. And any relationship with a client has to be established only through a written agreement. That's for your protection and for ours. So with that said, I want to get on into the substance of what you're here to get to understand. Our mission as a law firm is simple. We want to make sure that landowners, property owners are educated and empowered, that they understand the process and the risks, the complications, the benefits, and all the strategic and relevant legal considerations so that they can make educated decisions about how to manage sometimes their most important family asset, whether it's their personal home, their business. But ultimately, the things that we want people to understand is that in my work, knowledge is power. And we want to make sure that people who are for encountering an eminent domain condemnation related project for the very first time understand what their basic rights are, and so that they are not at a material or substantial disadvantage, and so they don't become exploited or abused by powerful entities like corporations, utility companies, and governments. We want a fair and honest engagement when it comes to determining and protecting the difficult choices that have to be made when it comes to public works and infrastructure projects. And we want to make sure that, in fact, we provide citizens, landowners with the tools that are necessary so that there can be genuine equality and fairness in that process. I'll tell you a little bit about myself and about our law firm. As I said, my name is Shiloh Dahm. I'm coming to you from here in the state of North Carolina. Well, Seaver Story Walker is a national litigation boutique law firm focused exclusively on protecting landowners' rights in eminent domain and condemnation cases. I give presentations like this all over the country, throughout the Midwest and the Far West, certainly in the Southeast. Our firm has spanned literally from coast to coast, from Oregon to New York, to the Southeast, to the Texas Gulf Coast. So we are focused exclusively on a particular area, on a niche area of law. We're proud of the work that we do and the results we're able to achieve. But we're specialists, and we don't seek to be, do anything other than eminent domain and zoning related litigation work. I'll tell you a little bit about myself. I am a resident in North Carolina, as I said, and have lived and worked throughout the Southeast, and I've worked elsewhere throughout the country. I've been practicing law about 20 years. I was educated at the University of North Carolina School of Law. I graduated with honors. I held a number of academic distinctions. Most of those aren't terribly relevant. What is most important to somebody now is the fact that collectively our law firm provides our clients with a combined in excess of a century of experience of eminent domain litigation related experience. And we leverage that considerable resource to protect and advance their needs, their goals. The reason that we do this, and the reason I'm coming to you from what is currently my time after 9 p.m., is because, as I said a moment ago, we ultimately want to make sure that people are protected, that no one finds themselves exploited. The thing that's most frustrating to me is to find out after the fact, too late, that somebody has signed an agreement that allowed a condemning authority, whether a utility line or a transportation department or some other condemner, to take advantage of them because they didn't really realize that they had any other choices or they had the ability to fight back and to seek additional compensation or protection for their property rights. If we achieve nothing tonight, hopefully then you will be a little bit more well-equipped and have a bit deeper and better understanding of how to avoid any potential pitfalls. And I'll give you a couple of specific things to do and not to do that you can look forward to and take with you from tonight's conversation. I want to start and just give you a basic overview about this project. You all are experts in your own communities, and I'm not going to pretend that I'm going to have superior knowledge about it, but I do want to give you kind of the wide angle view. This project is part of a series of larger regional infrastructure projects, totaling over 2,000 miles of additional electrical transmission lines. The Rocky Mountain Power refers to this as the Gateway Central portion of a large-scale, multi-decade infrastructure enhancement endeavor that they're undertaking. That's going to cost billions of dollars. So these are companies that are investing huge amounts of resources, time, money, and financial commitments into these large-scale corridors. These are larger transmission projects. This is not the local service line that brings power to your home or business. These are larger, long distance, as you can see from the regional map, across vast distances of moving power from where it gets generated to where it's located. This project, according to its advocates, is being developed because of simply the growth in the demand is there. I don't have to tell anybody on this call that the Intermountain West is booming in terms of growing population and demand. More and more people are coming there every day. And this project, along with others, are a part of the energy company's goal to try to provide additional redundancy, connectivity, and capacity, and hopefully some resiliency to a grid that is facing increasing demands. I know some people have tremendously strong feelings about issues of power generation, whether it relates to renewable power, conventional fossil fuel power, things like electric vehicles and those kinds of things. I'm not going to talk about that because ultimately this is a project that is sort of exempt from those kinds of political conversations. I do encourage people to be involved in the political process when it comes to advocating for those kinds of issues. But really what I'm going to focus on is once a project is planned, built, and approved, then what do you do at that point? A lot of the most frequent questions that I receive from landowners is, can I stop this thing? And in all likelihood, given the multi-state and multi-phase project nature of this project and the fact that it is just a smaller subsection, is I don't anticipate that there is going to be any significant meaningful likelihood of somebody being able to stop this project in whole. As I said, the things that are driving this project are not part of the renewable energy debate, really, in so far as regardless of whether or not energy is developed and generated from fossil fuels, renewables, or some other characterization, that more power is needed in every sector in this area. That's why it's happening, is because of the growth. And as a matter of resources, stopping a project is extraordinarily difficult, especially electrical projects. Pipelines are a little different. Pipelines have a much more checkered record of success, especially petrochemical pipelines, but even some other types of new and evolving pipeline technologies and infrastructure have had a very mixed record. But electricity is sort of the one universal that we're not aware of any meaningful likelihood of probability that a project like this is going to be able to be stopped. As it relates to individual property owners, you might have success in encouraging a rerouting or a modification of proposed power line corridor alignment, or making some other smaller concessions that don't necessarily stop the whole thing. But ultimately, it is important to understand the reality. That said, you're welcome to continue to lobby local, regional, and national decision makers in the government who may be in a position to change that calculus. I include this slide because I find it reminds me of the very first thing I ever, at least the first lesson I ever got in eminent domain law. And it's this notion that maybe a little romanticized notion as experienced by Bugs Bunny, that a project like this can be stopped or substantially diverted. As I said, it's a lot easier to do in a cartoon than it is in real life. Here are some basics about the project, and I'm not going to spend a great deal of time talking about this because we don't have a great deal of information about the specifics and details just yet. But I will sketch out for you what I can. This is what I would consider a mid-level or long-distance transmission electrical project. The voltage of these lines is going to be 345 kilovolts. Again, that's right in sort of the mid-tier for voltage for distance transmission. And it is going to be, the corridor is going to be installed utilizing the depicted steel monopole design. The steel monopole is the preferred design for most projects of this type and size. You don't get the large lattice steel monster structures that you would see in truly huge, super high capacity transmission. These monopoles are a little less intrusive. They don't have as big of a physical footprint, so that's some good news for folks. The routing is to go from the Limber substation in the southwest of Salt Lake, Greater Salt Lake, near Grantsville, to the terminal substation in sort of west central Salt Lake City, not far from the industrial zone, just southwest of the airport. I'll show you a map in just a moment. This project is expected to span approximately 56 miles, and these monopoles are going to be right around 100 feet. They may go upwards of 120, even 140 feet in some cases. And the span between the poles will range between this 250 to 350 feet. That can tell you that there's going to be approximately 20 poles per mile. If that's any indication or point of reference for you. A really important detail is the anticipated right-of-way width of this project is going to be 150 feet. So that means at the base of these poles, there's going to be approximately 75 feet on either side. That's going to be a protected utility corridor, where in the utility company is essentially going to have almost exclusive rights of use and not ownership, but use in the easement area. Also importantly, this project will reroute some existing transmission lines. In large part, this project may run alongside some existing transmission capacity and do what's referred to in the industry is called co-locating, meaning that they are going to locate some new infrastructure directly adjacent to existing power lines. That makes sense for a lot of people from a land use perspective. You already have some utility infrastructure there, so it's sort of an obvious choice. That can have some particular complications, though, in terms of how the route is laid out and how it will affect any individual property owner. So just because you have some existing transmission lines, you can't necessarily be certain that it's going to run neatly alongside it. It may overlap, or again, there may be some rerouting. So if you're one of the people who are having a rerouting of existing transmission lines, that's going to be really important and potentially substantially more impactful. In eminent domain and condemnation matters, we are always more concerned with the impacts to previously untouched, unspoiled property than we are to property that is already burdened by existing infrastructure or easements. The legal foundations of eminent domain condemnation go back literally hundreds and hundreds of years. They even predate the foundations of our country, but they are thankfully embedded into our federal and state constitutions. The 5th and 14th Amendment, the federal constitution, as well as the Utah state constitution, each essentially create limits and outer boundaries for eminent domain takings. And essentially what they say is that a property or a project, that property can be taken for the public use upon the payment of just compensation. And so the bargain is essentially we as a society collectively have decided that for things like commonly and collectively used infrastructure, things like roads, schools, that we're allowed to take the private property of some individuals so that for the collective benefit, but that person has to be paid and compensated fairly for the loss of their private land. These things are intuitive and they're sort of baked into our civic culture. In addition, there are certain specific limitations imposed under Utah law. Specifically, the public use requirement in Utah has to be authorized by law, which it does specifically include power lines on this type of infrastructure. So that's not necessarily a defense to this project. The use has to be reasonably necessary. And the standard of proof for that is relatively low, again, leading to my forecast that fighting a project like this is not likely to be successful. The project or the acquisition of property in the public use has to be reasonably related in time. So I can't take a piece of property for today that if I'm a project planner that I'm not going to use for 50 years. That's an unreasonable amount of time. And ultimately, the big question is whether or not and how much just compensation is going to be paid to the person who's being deprived of their property. Utah has an interesting exemption just on two major categories. First off, eminent domain and condemnation power does not generally include things like pathways, walking and recreational pathways, or bridle trails for horse traffic and things like that. So if you're worried about somebody putting a recreational path, a hiking trail, or something like that across your private land and saying it's for the public use, that's a whole other matter, not something that's applicable here. But there's also this exception specifically for century farms. So established agricultural farms that have been within the same family for 100 years, or that are part of a designated sort of green belt category, can have and do have certain additional protections. If you find yourself or think you might be one of these entities, or have a property that applies for this century farm exception, we can talk about that individually. That's a rather nuanced circumstance. Here's a general map of the terminal limber project. This is the segment C section. As I said, this 50 plus miles. You'll notice that it starts in the south and west, south of Great Salt Lake, and there are two details I want to point out to you. The purple line is a smaller feeder line, or just smaller distribution line in the Tooele community, and goes south of the Army Depot there. The main trunk of the line in the lower left is the Limber substation, which is going to be a new and additional proposed substation that's going to be constructed. And then that's going to feed north around Grantsville, and then cuts east along and follows more or less the edge of the lake, and roughly the contours of Interstate 80. You'll notice and be familiar with a lot of this area, especially as you get closer into Salt Lake City, and the terminal substation area is already highly developed, is substantially industrialized. You have a different situation if you are talking about, you're a property owner with an agricultural operation, you have a farm and you have crops, and those are materially different than if you own a large industrial building that's going to be impacted by a property like this, or if this is your primary residence. Again, those are three different kinds of categories of common cases, each of which they're going to have meaningfully different experiences as a property owner, and different considerations for ultimately what's important in terms of the way that compensation is established and evaluated. Here's a little bit more detailed look at the maps, and some inset maps. And again, I'm starting on the right-hand side is the terminal substation, currently in Salt Lake City proper, not far from the airport, and a heavily industrialized part of the city. As you go west out of it, you go to the left. To the upper left is the Magna inset, and again, the indication the tailing ponds is in and around heavily mined, or heavily industrialized areas. Continuing farther along, we get into the Lake Point area, and then unfortunately the nature of these slides and maps is a little bit confusing. The right-hand side, where the Tooele Substation Canyon Road area is, and the Army Depot is substantially more to the south. The ERDA map on the upper left is between the Lake Point area and Grantsville. So just again, how these are structured is a little bit maybe a little confusing, but I had to do it this way because in order to make them reasonably sized for the display for the conversation tonight. Finally, again, Grantsville, that's on the west side and the farthest west point. And then as you continue down on the below Grantsville is where it ties back in to the Tooele map from the earlier page. I want to point out that the map indication, the map key and map legend here on the bottom gives some helpful information. A few things that are not illustrated here are the feeder lines. These are the higher voltage 500 kilovolt lines with a wider right of way, and those are not shown on these detailed maps, and they feed in farther from the south. There's already some existing infrastructure that's been built over the last several years feeding up from the south that comes into and ties into the Limber substation. And that's a little bit that is work in the project that's already been done, but it's important for the folks in those communities. That's how you get there from here. And essentially what we're looking at is a project that is coming up from the south, going up to Grantsville, and making that hard right-hand turn to go towards Salt Lake. If you want some additional information about the routing of this project, I encourage you to contact, and we can talk individually offline. We have a little bit more detail, can perhaps provide some additional more detailed information. But understand that the details about the project that I've given you so far are essentially what Rocky Mountain Energy has provided and stated publicly in some of their public meetings. Hopefully some of you got a chance to go and participate in some of those public meetings and informational sessions back in March. Hopefully the news about this project is not, in my letters, is not coming to you as a complete surprise. But the best source of information right now in terms of those kinds of details is probably to refer you directly to the project managers at PacifiCorp and Rocky Mountain Energy at this point. I want to talk to you a little bit about sort of the process and again what you can expect. If you haven't already, as I said, you should expect contact from the utility company. More commonly than not, though, in cases like this, utility companies subcontract out work to acquire property to what are referred to as land agents. Some of you may have dealt with land agents in various capacities in the past, as it relates to any number of rights like water rights, or somebody representing a property owner. This can also be important, again, in terms of zoning and development considerations in your local municipalities. But at some point, they have to contact you, give you some essential information, and give you notice that this project is coming and your property is being affected by it. The statutes in Utah require that the acquiring utility company engage in good faith negotiations with you. And they have to, as a part of that process, they have to give you a few specific notices. Your state's a little bit unusual in that it requires a couple of specific things to be spelled out, including to give you written notification that nothing that is said to you in person, no oral promises, will be binding on the company. This is a byproduct of too many people who've been sort of swindled or been told one thing in their living room or around their kitchen table when they're talking with a land agent who's slick talking and trying to get them to sign on the dotted line. And then the paperwork that's presented says something entirely different. So take that as a cautionary tale. The only thing that matters in property rights such as these is what is written and recorded in the relevant deed and property records. Those are the promises, those are the restrictions that everyone is committing themselves to. And those are the things, the rules that are going to govern you and your property for decades and generations to come. So that's why, fortunately, you have the protection that says, and are to be reminded that you can't believe everything you hear when it's told to you simply and orally. Secondly, the mediation and arbitration through the state property rights ombudsman. The state of Utah is rather unique, again, in that it has a specific office that's acts as a bit of a clearinghouse for property rights and property owners in connection with eminent domain cases. And they're there as a liaison between you and the company in some ways. And I'll talk a little bit more about that in a few moments. But they are the body that facilitates the potential negotiations between you and the condemning authority, the utility in this case. A lot of people want to understand, well, can they come on my land? Do I have to allow them access to survey the land? Or can I prohibit them and keep them off? Is that going to help? My general message is that in nearly every state that I'm aware of, that survey access to land is permitted by statute, and what we will simply require them to go and get a court order. And they can go and they will file potentially a separate lawsuit in order to seek a court order that allows them to come on the land to do surveying, sometimes also to do additional soil testing. Now, anything that they mess up, it's the old pottery barn rule, you break it, you buy it. Well, if they mess something up, that they tear down fencing in the course of doing their survey activity, then they're responsible for paying for those kinds of things. But as a general rule, you cannot, at least in the long term, prohibit them. You might be able to delay it, but it's relatively inevitable. in our experience, generally speaking, we advocate and encourage our landowners to work cooperatively with the surveyors. The reason is that we, as much as the utility company, need to know exactly where where a project is going to be located, what exactly the lines of the boundaries of a particular dispute or a taking are going to be. And that is the only way everybody can begin to get a common set of facts from which to make a decision and an assessment about valuation and other issues. So as I said, you're better off reaching reasonable accommodations with the surveyors and the utility company representatives, because it will actually put you in a better position and give you more information rather than less. In a situation like this, the land companies the companies acquiring land, that is, are going to have to do an appraisal on your property for the damages that are likely to be caused. And that appraisal has to be disclosed to you as a property owner. That is a requirement in the state. The appraisal is there to determine and to meet the legal and constitutional requirement that a property owner be paid fair and just compensation. Now, what is just compensation is what amount of money would be just, is essentially defined almost in every state the same way. It is the impact to the fair market value of the property caused by this project. Now, specifically, that can include the market value of the property that they're actually taking or occupying or depriving of. It includes the value of any improvements, structures, any changes to the property. If you've enhanced the property anyway, that we refer to those as improvements. That includes buildings. Any kind of building is considered an improvement. It also refers to severance and remainder damages. These are the damages that are to the property, not that they're taking, but it's the adverse impact of the value of the property that they are not touching, but that is nevertheless devalued by the location and proximity to this new power line. So, for example, if you had a $500,000 house, nice, large, lovely home, and somebody put a property or a power line a few feet outside the bedroom door, we all intuitively understand that that's going to have an adverse effect on the value of that home. It would diminish its marketability and its desirability to other potential purchasers in the marketplace. So that is the type of, even though they're not taking the home itself, they are potentially devaluing it. And so that's a type of severance or remainder damage. They also have to pay for any temporary occupation of property. I indicated a few moments ago that this project is anticipated to be a 150-foot width corridor, and the right-of-way is going to be that width. But oftentimes they require more than that, particularly in some key areas. They're going to have to do work on the project such that they're going to have larger staging areas and have to put equipment places to stack the poles and the wire, and to have trucks and construction trailers and things like that. And so it is very common for a property like this, or a project like this, to have a 150-foot corridor, but maybe 25 feet on either side of additional temporary workspace. Or at some places where there's a key road crossing, or they have good access to the interior parcels of a power line, they may take a 250 feet width, so that they have, again, they can get trucks, equipment, vehicles, and things like that in there. So just don't be shocked if you find out that you have temporary property that's temporarily affected in addition to what's permanently affected. Another element of just compensation can be cost to cure. Let's say, for example, that you are on a septic system, and for whatever reason they have to destroy or impact the septic system of your property. Well, if it costs you $40,000 to install a new septic system on the opposite side of a building, because the existing side is being taken up by the power line, that is an element of damage, even though it may or may not be fully reflected in market valuation, in terms of sales or fair market value. Ultimately, the question is, what is the before value of a property and what is the after value of a property? On the last slide, sorry, the other thing to be important, another important consideration is a highest and best use. The highest and best use of a property is a technical, legal, and real estate term as it relates to this kind of conversation that suggests and asks, and I'll come back to it in a few minutes, but essentially, what is the most economically valuable use of a particular property? And we'll talk in more detail about that in a few moments. To determine the valuation of a property and figure out what the before and after value of a parcel is, appraisers typically utilize three models. One is the sales approach, and that's the one that if you've ever bought and sold a home, you're most likely to be familiar with. It's, do you have property, another property that has sold recently in the marketplace that is reasonably comparable, from which I can infer a market range. This is the type that is generally considered to be most reliable, preferred by condemning authorities, and certainly preferred by appraisers. Another valuation model relates to is the income approach. And this is very applicable to any commercial or revenue producing property. If you owned a whole apartment building, you're not going to buy and sell individual apartment units based on their use. Instead, you're looking at what is the income potential, that the revenue long term that they provide, and that gives you an income valuation that is an identifiable and determinable asset value. That same thing is true if you have a commercial property. Say you have a storefront or a small strip shopping center. Again, it's not necessarily the sales version. Comparison version of that may be helpful, but oftentimes, certainly, a lender or other market participants are going to look at what is the potential revenue that can be generated by that asset, by that underlying property, and the total market value is actually derived from that. And lastly, the least common, generally speaking, is the replacement value. This is best for unique properties, and those are properties that don't either have a significant income approach or income associated with them, nor are they commonly bought and sold in market transactions. One of my favorite examples is a case I had years ago that involved a volunteer fire department. You don't go buying and selling things like that, or churches. There aren't commonly churches bought and sold, especially because they have such a unique layout and design to the space. And so you'll say, okay, what would it cost to rebuild something like this? And that's a way of inferring and determining the actual market value. And that incorporates an element of cost to cure. As I said, if you have to make changes to an existing property, even outside of the area, that's an element of damage that's included in the valuation perspective. One of the things is to go back to the process. At some point, they're going to come to you and they say, we need to acquire this portion of your property. We have to do a survey. After we've done the survey, we're going to send in an appraiser. We're going to value the property. And we're going to figure out that before and after. Under Utah, there's provisions where a second appraisal can be ordered by the state, and that the utility company will actually have to pay for. So that's a really nice option that you guys have in Utah that not every other state has. Ultimately, if you're not able to reach a resolution, if there's not able to be a consensus reach or a satisfactory agreement to determine what the compensation to be paid is, ultimately they'll have to give you an advance notice, and before they prepare to file to take the action through an actual eminent domain action or condemnation taking. Throughout the state, even adverse parties will agree, once you're in a condemnation lawsuit or facing a likely condemnation lawsuit, it is really vital that you have competent, experienced legal representation to represent you. The other side is going to have lawyers, and you would be ill-equipped to begin be on even footing if you do find yourself in an active litigation. Quick take powers are what happens when once a lawsuit is actually filed. Let's say that you're not able to actually reach an agreement or resolution, that they're never able to or willing to put up adequate compensation that's satisfactory to you. They give you the requisite notice that they're going to file an eminent domain lawsuit, and then they do that. And then ordinarily, and you're going to be in a position where they are going to be able to obtain possession of the property. The idea behind quick take litigation in condemnation cases is that they need to be able to move forward, and an individual landowner who's holding out because they want more money doesn't necessarily stop a larger infrastructure project. So that's the thinking behind that. The Utah Code, it provides the specifics of the litigation procedure. I'm not going to get into that here because that's a good ways off. But I do want to point out that under Utah, which again is a good thing for you to have, that certain costs like filing fees, certain expert witness costs, and importantly, attorney's fees can be recovered if you go through litigation and trial in Utah after there's been a qualifying offer recorded with the court. Those numbers are capped $50,000 for an individual owner or $100,000 for multiple owners in terms of the overall legal fees that may be collected. But that's a really, really helpful incentive that keeps the utility companies in this case from sort of sandbagging and giving you ridiculous low offers, because if they do proceed with litigation, then they can wind up being on the hook for attorney's fees and for your attorney's fees later on down the line. I said a moment ago that the highest and best use for property is an important thing to consider, and an appraiser will certainly do as that'll be part of their evaluation. And the highest and best use isn't necessarily the use that a property currently has. Again, in a growing community, this is also quite intuitive. If you live in an area that is amenable to commercial or residential development, and property has historically been used as pasture land or for agricultural purposes, you are not necessarily limited to the current valuation of that land in its undeveloped state. Rather, you're allowed to capture or consider essentially what is the future development capacity and the highest economically and maximally productive use of that land. Now, you can't just imagine, hey, that there is a massive hotel on an empty 2-acre lot and say that you're owed millions of dollars based on an imaginary object. But the highest and best use principle does allow you to capture again the potential upside of your property in a significant fashion. If you do have a piece of property that you believe has a different highest and best use than its current use, that is again another important consideration, and the kind of case where you may have to have some additional time and opportunity to develop the facts and evidence that are necessary to support your valuation claims when you're seeking to maximize your compensation. Do you have to take their offers? And I hope you've gotten enough so far to understand that you don't. That the offers that they come in, while they will be supported by an appraisal, oftentimes that first appraisal is not very credible. It's not necessarily well supported, and it's not necessarily, frankly, very reasonable. In our experience and those of many other landowners and other attorneys in the field, we generally recognize that those initial appraisals are oftentimes just a starting point, which is part of the reason why your statutes allow and protect you and require them to provide a second appraisal. I want to give you some really important and specific takeaways, things that you do want to do and what you don't want to do as you move forward in this process. First off, as I said early on, knowledge is everything in these areas. Do you want to ask as many questions as possible, get as much information from the utility company about your land, about the taking as you possibly can. Ask for any copies of any documents that they're utilizing or considering. For certain, you'll ask for the appraisal that they perform on your land. And importantly, you can ask for any additional supporting information that is related to the appraisal. Whether you get that's a whole other conversation, but it never hurts to ask. Do keep copies of anything that's given to you by the right-of-way agent. Keep detailed notes. Keep any emails, text messages, anything like that. The more written documentation you have in connection with a case that you may be facing, the better off you'll be. If you are somebody who's facing relocation because your whole home or business is going to be adversely affected and is going to have to no longer be occupiable, then you have a specific and a particular set of additional issues that you want to tackle. That involves relocation, and it's a whole other topic conversation as a subspecialty as well. But reach out to somebody again earlier than you think is necessary, because the relocation process is requires an extraordinarily careful and long lead times in order to be likely to be most successful. Keep good notes. Anything that you have as it relates to anything related to the compensation, the proposed taking, the impacts, any changes to the alignment of the power line, things like that, is going to be really important. So the more information that you have in writing, the better off you are. Even if they say that they're going to be taking, an improvement, they're going to be taking a shed, an outbuilding, something like that, continue to maintain that property. Do not let it go to into disrepair. The reason for this is that the date of the valuation to determine what just compensation is the day that a lawsuit is filed. When they file that, and sometimes they may experience project delays, maybe there's regulatory delays. For any number of reasons, you could find yourself, the land agent tells you, oh, we're going to be ready to buy your property in a few months' time, and you allow it to go into disrepair. Well, 2 years later, maybe they say, well, guess what? Your property is worth less because you haven't maintained it. So in those cases, you have to continue to take the timelines and the anticipated sequencing of a project with a bit of a grain of salt, unless and until they actually give you the firm notice that they're intending to file a lawsuit, in which case those things are, by then it is pretty clear what's going to happen and when. A couple of things that you don't want to do is to settle for their first offer without talking to somebody. And by talking to somebody, it's important to evaluate and talk to an attorney who has specific qualifications, experience, context, and the knowledge base to be successful, help you successfully negotiate a good result. You don't go to a podiatrist when you have heart trouble. And this is the same way. You don't want to contact an attorney who doesn't have a specific background and a good grounding in this area of law. And I say that not to be selfish, because certainly we're in the business of helping landowners like yourselves. But if there's one thing that folks I hope take away from tonight, is even if you don't want to work in our law firm or somebody else, you do owe it to yourself to at least talk to somebody who's qualified to get another perspective, because you don't know what you don't know. I can't tell you how many times I've had landowners come to me and tell me about their case, and then experience a bit of remorse when they discover that there was something in the law or something in the factual development plan that could have meant that they lost out of tens or hundreds of thousands of dollars of potential compensation. I had a conversation just last week with somebody who was actually in the real estate and development business, who had thought he was sophisticated and capable and qualified, and could handle something on his own, their own, for their family. And they probably cost themselves well over $500,000, just because they were overconfident in their ability to potentially negotiate something, because they didn't know certain areas of the law and certain rights that they might have otherwise had. So as I said, if you don't talk to us, talk to somebody before you at least make any final absolute decision and begin signing on anything. Don't tell the right-of-way agent or anybody what you think that your property might be. Even if you have some sophistication, as I said, you may not actually know. The market has been rapidly changing in the last couple of years, as we all know, and you may substantially undervalue the potential range of compensation that could be you might be entitled to. Any experts that you think you have, even if you have a friend of a friend of a friend who's as an appraiser, be very, very cautious about utilizing somebody who is not an expert and in this particular type of work. An eminent domain condemnation litigation appraisal is very different than any other kind of appraisal. And it's very much different than any appraisal that you got, say, the last time you refinanced your house, or when you first bought your home, or anything like that. And so I can't emphasize enough that if you do have a significant claim, you do think that maybe you have, and maybe it turns out that an appraiser that can be a good resource. But whatever you do, don't necessarily share that information with the the other side, at least not without doing it in a strategic and thoughtful way. Don't speculate about the value of the land that you have. Everything that you say about your land is going to be written down in one of their notebooks and could be part of a future lawsuit, and could be, as I say, used as evidence against you in a way. So the other thing is that oftentimes appraisers and land agents will say, okay, well, we think that your land is worth this, and this is what we're going to pay you. And you see that number and you say, oh, obviously that's way too low. And they say, well, what would it take? What is a good number? What's satisfactory to you? I want to caution you, do not answer that kind of a hypothetical question. You don't actually oftentimes have enough information to give a reliable answer, but more often than not, you may be staking yourself out. And that is a part of their negotiation and acquisition tactics and their strategies. And so essentially it's kind of they're trying to lure you into making a bit of a sucker's play. And so don't be misled. Don't give an answer. You don't have to give an answer as to what you think the property damages might be without talking to competent counsel first. The other thing is you don't want to do is to complicate things and again, step in and encounter some unanticipated pitfalls, things like by try to do zoning changes and getting additional subdivision approvals or something like that. You could actually, again, make things worse while you're trying to make them better. If you do it in collaboration, consultation with a lawyer, that's a whole other story. But to just kind of go freelancing on that kind of thing is definitely not advisable. Ultimately, you don't want to go alone. In a case like this, you owe it to yourself to have some competent professional advice. The condemning authority, the utility company, they're going to have whole teams of people, capable lawyers that work for them, land agents, sophisticated parties who negotiate these kinds of issues all the time. They're going to be very familiar with this, way more than familiar with it than you will ever be. So you do owe it to yourself to at least get an educated perspective from somebody and get a consultation. Oftentimes people ask me, okay, well, if I'm suggesting everybody should be talking to an attorney, when and how do you go about hiring that person? Well, in my line of work, sooner is always better. The more time that I have to deal with a potential project, the more time I have to develop the facts, the evidence, the appraisal and valuation evidence, the better off the property owner is likely to be. The last thing is that I want to get is a phone call from somebody saying, oh, I've been sued and I have to respond within 3 days, or that this a case has been building and going on for years. Don't find yourself in that position. Don't box yourself in, and do not wait to the last minute. I want to emphasize to folks, in particular, again, under the state statutes, there are provisions that allow for people to get an evaluation and to even get a second appraisal. And you should avail yourselves of those opportunities. Not every appraiser is created equal, and not every appraisal are going to be created equal. So the way that you select and execute on your litigation and negotiation plan is really vital. The good news is that folks can work with our firm and other firms like us, typically on a contingent fee basis. So you don't have to write a large check right up front. We only get paid, generally speaking, when we get a significant increase over the amount of the offer that the utility company is giving you. Ultimately, I want to ask you to ask yourself and face this possible scenario and consider just how wrong they can be. And the truth is that sometimes they're just a little bit wrong. And this is a case example from Wisconsin. Involves a utility case where, and again, it's just a little bit. They offered a landowner $12,500. We got involved and we're assisting the property owner, and we got them $28,500. So that is, an increase that's essentially a little more than twice what they were originally offered. So an increase of about $16,000. That's real money, and it represents a fairly typical and common kind of a scenario where landowner got a significant increase, even though the impact of from their property was maybe not as severe as it could have been. Sometimes how wrong their estimate of compensation can be much larger than that. Another similar situation where we had another case in another state, Ohio in this case, there the utility company offered our client $60,000 in their initial offer. After a considerable time, and again developing the facts and the evidence, we were able to obtain nearly 10 times, roughly 9 times in this particular case, the amount of original compensation. That is obviously a huge kind of a difference. I bring these examples up not to wow anybody or to give a false sense of or expectation that we can achieve that kind of result in every case. Every case is different. Each piece of property is unique, and we have to take them based on the facts that are presented. But what I want you to take away from this is the idea that the subjective value of a particular piece of land and how you analyze this problem of compensation can lead to vastly different outcomes. And even if the people in the Ohio example that I gave you, had gotten 2 or 3 times the original offer, maybe they had been satisfied, but they would have been leaving hundreds of thousands of dollars potentially on the table. And our goal, as we said, is to make sure that you understand what the ultimate sorry about that, I hit the wrong button, what the ultimate result is and how you can best position yourself and your family to make the right choice for you. I'm really nearing the end of my remarks. I do want to remind folks, though, I encourage you to spend some time on our law firm website. We have a tremendous amount of information that talks about the eminent domain and condemnation process, gives you things to consider from the perspective of the landowner facing a power line such as this. Gives you some examples, and here's how cases have unfolded before and some of the things you want to consider. It tells you a little bit about who we are and how we've spent the last series of decades representing hundreds and hundreds of landowners throughout the country in cases like this. Ultimately, if you want a more individualized consultation and more individualized nuanced assessment that deals with the facts and the particulars of your property, I invite you to reach out and contact us directly via my email or my telephone number that's attached. There won't be any cost for that kind of consultation or evaluation. I'll give you my honest, candid opinion as best I can with the information that we have at this stage. I do want to tell you this project is still in its early and developmental phases. You're still in the public meeting process. There's likely to be time that the project timelines are more reliably announced. They're not going to be breaking ground on this project until at least next year and quite possibly beyond that. There's a great deal of regulatory local approvals that have to happen still, but we're here early talking to folks because we want to spread the message and make landowners understand what the potential risks and issues are. I'm going to end my screen share now and go back. I want to encourage folks to, as I said, to continue to reach out to me directly. You've got our telephone number, you've got the information on the website and our email. If there are specific questions that we can help answer, we stand ready as landowner attorneys to try to do our best to give you the best possible guidance and encourage you to continue to empower and educate yourselves so that you are in the best position, able to make the best decisions for your property in the circumstances when the time comes. I appreciate your time, attention. It's been a nice talking with folks, and I look forward to hearing from you soon. Thanks.